Today's date is April 7th, 2022, and the court's going to hear two cases by Zoom this morning. And counsel is the same on both cases, so we'll roll right from one to the other. Today's panel, as you can see, is Judge Hensel, Judge Callahan, and myself. I'll be keeping track of time and presiding. And we're going to start with case number 21CA011745, State versus Mr. Lopez Olmedo. Each party, as you both very well know, will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Attorney Brenke, just let me know if you're going to reserve time, and I'll let you know as you get close, as you know. The arguments are being recorded and posted on the court's YouTube channel, so you both are aware of the rule that we don't like victims or children's names being used on the video. With that, I can assure you that we've read the briefs and we are prepared to proceed if you are. How much time would you like to reserve?
5 minutes, Your Honor.
5 minutes. All right, I'll let you know as you get close. Thank you. You can proceed.
Thank you. Giovanna Bremke on behalf of Mr. Lopez Olmedo this morning. Well, for the first one, I see that Lindsay and I are the main event today, but Mr. Lopez Olmedo was indicted in December of 2018 on 4 counts, including trafficking in drugs, possession, and drug paraphernalia. The case proceeded to a jury trial in March of 2021. Interesting enough, because of COVID and exposure to COVID, the court reporter appeared by Zoom, but the rest of the individuals were in person. So the jury and attorneys and my client and the judge.
Hey, before you go on, was there some sort of agreement between the parties that's the way the court reporter was going to appear, or is that just the way the court set the trial up?
I imagine it took place off the record, because it's not it's not something that was. It was clear that the court reporter was not in person in the record, but the discussion regarding that was not on the record. So I imagine it was maybe a chambers conversation that didn't make its way to the record. Thank you. Mr. Olmedo was eventually convicted on counts 2 and 3. Counts 1 and 4 were dismissed. There was also specification, so he was sentenced to 11 mandatory years. Essentially, the facts, I'll keep it brief, but the police executed a search warrant. They recovered drugs, and there were many family members who were there, at least 17 individuals at the home. And I think 10 of them were family members at the time of the search warrant. Mr. Lopez Olmedo is Spanish speaking, and there was a Spanish interpreter there. However, the record reflects, and the first assignment of error deals with the court's essentially the failure to provide an interpreter. Although there was an interpreter, the record's clear that he could not hear the interpreter because the individuals in the courtroom had to use a microphone so that the court reporter, who was remote, could hear. He couldn't, as a result of that, he could not hear the Spanish interpretation. So he indicated on the record that Spanish is his primary language, that he would prefer to have an interpreter in the courtroom interpreting for him. And
So are you saying the interpreter was on Zoom as well? The interpreter was not inside the courtroom for the trial?
No, the interpreter was in the courtroom, but the way they ordinarily work is they have headphones, but because of the magnification of the English language through the microphone system, because of the microphones are the way that you can hear remotely by Zoom. So the court reporter needed to hear the English language by microphone, and it overpowered the Spanish speaking, so he could not hear over that. So the interpreter actually says, and I cite to the transcript where she says this, but that he cannot hear her interpretation. And the court's response was, well, we have to amplify the English language because of the court reporter. So in essence, it deprived him of that interpretation, which he's entitled to under, RC 2311.14A1 and Superintendent Rule 88A. So again, in essence, he was not provided an interpreter at all because he could not hear that interpretation.
Counsel, regarding the record on that issue, if, as I read it, there were 2 interpreters, correct?
Correct.
And the court made a point of saying that they were sworn and got that on the record. But everything I read happens before the trial begins. And when I say trial, I mean opening, evidence, closing, all of that. Is there anywhere after the conversation that you're referring to where either interpreter or your client says, okay, I can't hear, this isn't working, anything of that nature?
I would agree with you that the primary conversation is before the trial begins, sort of when they're going over the preliminary matters at the beginning. I would agree, that's where the conversation takes place.
Okay. All right, thank you.
There's also sufficiency and manifest weight arguments. That's assignments 2 and 3. The sufficiency, deals with, the fact that there were other people in the home. Again, 17 other individuals. There's testimony that DNA was not taken on the items recovered. And one of the detectives, and this is transcript page 193, testified that the things in the home could not be attributed to Mr. Lopez Olmedo as far as his convictions. The manifest weight argument deals with a break in the chain of custody. So there's a lot of testimony. The lab director she never testified as to who got the substances from where and in the manner that she got it. There's Detective Straub, who testified that he assisted in executing the search warrant and located the items, but that never how they were handled. And there's also a special agent. So this is a search warrant. They had a lot of different departments, and that's something that the defense attorney goes over quite a bit. But the special agent also testified that he recovered substances from my client's waistband. But again, he was not, once he recovered them, he did not testify how they were handled. And the cases that I cite make it clear that the chain of custody is on the state. That's the burdens on the state. I would reserve the rest of my time.
All right, you'll have the full 5 minutes then. Let me just ask any other questions from Judge Hetzel or Judge Callahan. No? Okay. You'll have a full 5 minutes for rebuttal. All right, 15 minutes, Attorney Poprawski. I said that wrong.
Your Honors.
Poprawski, there we go.
Lindsay Poprawski of the Lorain County Prosecutor's Office on behalf of the state of Ohio. I'd like to note that the appellant's assigned error specifically provides the roadmap for this court's review. And in his first assigned error, Lopez Olmedo specifically asserts that the trial court erred when it failed to continue the trial based on a claim that he could not hear the 2 interpreters that were set up due to an arrangement that the trial court was used with the court reporter who was virtually participating in the trial. The state notes that in its brief that rather than developing that argument, Lopez Olmedo abandoned the idea that the court should have granted a continuance and instead invoked the Rule 88 of the Ohio Supreme Court Rules of Superintendents and a statute, both of which require courts to appoint interpreters to assist the parties understand the proceedings. However, the trial court complied with those requirements. He does not specifically assign as an error that an interpreter was not appointed. He then cites to a federal due process claim for relief. None of these arguments have merit. First, the record does not support Lopez Olmedo's specifically assigned error, that the trial court should have continued the trial. The trial court could not have committed that error because the record shows that Lopez Olmedo did not ever ask the trial court to continue the trial. With no objection in the record as to the trial going forward, in order to find merit in this argument, the court would need to find that the trial court committed plain error in not continuing the trial on its own. But Lopez Olmedo has not offered this court a plain error analysis, and this is fatal to his assigned error because it is incumbent upon him to make the required plain error showing. And this court has consistently noted that it will not construct a plain error analysis that is unraised and then address it on its own. The state would also note that Lopez Olmedo's due process claim is also unsupported by the record. The record does not bear out Lopez Olmedo's claim that he could not hear the proceedings, particularly after page 9 of the trial transcripts. After some preliminary matters unfolded, one of the two interpreters, but not Lopez Olmedo himself, told the court that Lopez Olmedo, quote, cannot hear really good. The issues were then addressed, and Lopez Olmedo expressly told the court, I want to go forward. The trial court ultimately moved forward, but instructed Lopez Olmedo that, quote, if there's a problem, you let us know. We want you, of course, to be able to hear everything. And Lopez Olmedo never indicated a problem afterward. And from then on, at no point in the proceedings did Lopez Olmedo communicate to the trial court that he could not understand or hear the proceedings.
Counsel, I just with respect to the court instructing him that we want to make sure you can hear the proceedings. If you can't hear what the court is saying as it's translated, how can we be sure he heard that instruction? I mean, it might be just the same problem perpetuating itself throughout the entire proceeding. And his response that I want to go forward, I'm not sure that was just a statement, or was that in response to something that was said to him directly?
I agree that I'm not clear from the record whether the response, I want to go forward, was in response to him saying something, was in response to something that was said to him directly. Mm-hmm. I would ask that the record be looked back at on that, but there's no indication going forward. I would say that he indicated to his counsel that his counsel represented that he could not hear anything. There's no objection in the record to indicate that he could not hear anything going forward.
Okay, thank you.
Okay. I'd like to next address the sufficiency of the evidence argument, and that is challenging the state's evidence that Olmedo Lopez did not prepare heroin for shipping or distribution. The state cited in its brief to cases in which this court has held that a convergence of illegal drugs, drug paraphernalia, including baggies, and large sums of cash permit a reasonable inference that a person was preparing drugs for shipment. And to support his drug conviction here, the state presented evidence that Lopez Olmedo had a little more than 188 grams of heroin on his person when he was arrested exiting a residence in which a law enforcement had secured a search warrant to search in connection with a drug trafficking investigation. 2 bars of manite were also located on his person at the time. Officers testified that drug sellers typically use manite as a cutting agent to stretch out drugs to obtain more money when they sell drugs. The state presented further evidence that when law enforcement searched the residence, they found baggies and a scale in a 3rd floor attic. At least 2 law enforcement officers testified that these items are commonly used to prepare drugs for sale. Officers also located a blender and a hand press, which they testified was used prior to sales to make the product finer and more compact, consistent with the blender that was found. Although the record does not contain a specific amount of money which was located, a sergeant with the Lorain Police Department Narcotics Unit estimated that the 188 grams found on Lopez Olmedo's person could potentially net more than $15,000 when sold. Taking that evidence in the light most favorable to the state, those items would allow a jury to reasonably infer that Lopez Olmedo was preparing heroin for shipment and distribution and was sufficient to support his conviction. The state would also point out that Lopez Olmedo's arguments that the evidence was insufficient due to lack of DNA evidence and the fact that there were many people in the home at the time of the search goes to the weight of the evidence, not the sufficiency of the evidence. His observations highlight what was not within the state's evidence, but the sufficiency analysis considers the evidence that the state presented and it examines that evidence in the light most favorable to the state. Lopez Olmedo does assert a manifest weight argument, but that assigned error was limited to the argument that multiple breaks in the chain of custody weigh against the credibility of the evidence. He criticizes the lack of testimony that the state elicited about the handling of the drugs in its chain of custody. The state would submit as to that argument that it put forth State's Exhibit 49 before the jury, which a special state agent testified was the contraband that he removed from Lopez Olmedo's groin area and believed was contraband. The state also presented the testimony of Elizabeth Doyle, the forensic drug analyst who analyzed the suspected contraband to determine whether it contained a controlled substance. Ms. Doyle identified State's Exhibit 49, testified that she received it for testing, and that it did in fact contain heroin, which is a Schedule I controlled substance, and that it weighed slightly more than 188 grams. State's Exhibit 49 was admitted without objection, and neither the testimony of the special agent or Elizabeth Doyle was contradicted or impeached so as to draw the credibility of their testimony into question. Because this is not the exceptional case where the evidence weighs against conviction, the state would submit that Lopez Olmedo's third assignment of error should be overruled and that his convictions and sentence be affirmed.
Thank you, Attorney Paparaki. Any questions, Judge Hensel? Judge Callahan? All right, very good. Attorney Bremke, you have 5 minutes then for your rebuttal.
Thank you, Your Honors. Just a few things to note from the state's presentation. Part of their argument is, well, Mr. Lopez Olmedo was assigned interpreters, so that was good enough. But the interpreters in this scenario would be the same as if they were sworn in and just sat there. If you can't hear them, then it defeats the purpose of having the interpreter there at all.
How do we handle the no objection or no, counsel not indicating to the court or objecting at all?
Yeah,
how do we handle that issue?
It is addressed in the record at the beginning. And I will note that the state again says that well, why didn't Mr. Lopez Olmedo tell the court? But the issue is if there is that language barrier, that's always a problem. The record is pretty clear that the defense attorney was also English speaking. So there's a language barrier there between the client as well. And so when the state argues that the interpreter was the one to bring it to the court's attention and not the attorney, I think that's clear, because if the attorney also couldn't understand the client, then that's sort of something that needs to be accounted for, that the interpreter would be the only one that could have understood that. Another, as far as his comment of, I want to go forward, I think he has a right to go forward with a trial and with an interpreter that he could understand and hear. So just him saying he wanted to go forward does not waive his, right to say that he could not understand and could not hear the proceedings.
So are we limited to your assignment of error that the court erred in not continuing the trial?
No, I don't think that the court, that was the only remedy. I think they could have provided a court reporter in person to eliminate the issue.
I'm talking about the argument that your assignment of errors is addressed to the court not continuing the trial. And Attorney Paprocki is arguing that, hey, we're limited to that in our analysis.
Sure. I think this court is open to rule however they want, based on what the record shows. So again, I think that it wasn't, it could have been continued. It could have been provided with a court reporter in person. There's ways to remedy it. But in essence, the court reporter was not provided, and my client couldn't understand the proceedings.
Okay, thank you. You've got about 2 more minutes left if you'd like to use them.
That's all I have, unless somebody has a question.
Questions from my colleagues? None? All right. Thank you both for your arguments here this morning. Of course, we're going to take this matter under advisement. We'll issue a decision in due course, which will be mailed, a copy of which will be mailed to each of you on the day it's released. And the opinions are also available on the Supreme Court of Ohio's website.